We're going to deep dive into expert evidence today. My name is Julia. I'm here with Sydney Jacobs, Barrister at 13 Wentworth Chambers. You can find guidance and tips on expert evidence in LexisNexis Practical Guidance, Dispute Resolution, so please get in touch if you'd like to know more. So everyone, how do you currently write an initial letter of instruction to an expert? Do you kind of robotically repeat and write a letter of instruction similar to your previous letters, setting out a case summary and detailed questions to be answered? But apparently, there's a better way to go about it. So Sydney, I know you're not a big fan of an early detailed letter of instruction to an expert. What are your hesitations about doing it the conventional way?
Julia, my hesitations are on a number of levels. First and foremost, talking of commercial equity matters such as disputes about easements and things that you'd normally have in the equity division. There's no rule of court that says that one is compelled to set out a detailed letter of instruction. This is simply on the level of facial legality. For example, in the family court, as I understand it, there is an obligation on practitioners to say everything to their expert that they need to or have to say in writing or something like that. I don't understand there to be any analogous rule in the Supreme Court or the District Court, which is where most big commercial litigation is heard, other than, of course, the Federal Court. So firstly, there is no obligation to do it. Secondly, when it comes to the actual process that you engage in, one of the things that you want to ensure is that you're not investing a huge amount of money in a particular expert to get a report only to find that the answer is adverse, and that in the process you've created a potentially discoverable trail of documents that can be subpoenaed or reached upon discovery, and then they become boomerangs in the matter itself. So I'm not a huge believer in writing a letter to the expert or advising my solicitors to write a detailed letter, then sitting back and waiting for them to write something in return, because of course you never know what you're going to get in return. So my strong preference is to, once one has ascertained that the expert is available and that the general area is within his or her field of experience or learning, to have only such limited correspondence with them as is sufficient to comfort them regarding their fees, and to give them the broadest brush explanation of what the case is about, sufficient that they're comfortable to have a conversation in person about it. So those are some of my hesitations. Those aren't necessarily all of them, but those are some of my hesitations in writing a detailed letter. So my preference is to strongly discourage any detailed early letter. Perhaps I'll add a third or fourth reason, I forget which number I'm up to, but another reason is that it's generally not a good idea, in my experience, to finally articulate the question you want answered before you've had a chat with your expert, because the expert might come up with a better question for you. And it's only when you have that fairly robust debate in person, preferably over a table and a cup of coffee, or if you have to over Zoom, that the question actually shapes up. And everyone's experience is I'm sure the same, that the longer one is in a matter and the longer you have to contemplate, the better the question it is that you can ask.
I see. So you should not open the door for the experts to write back and express some preliminary view before they know what the case is about.
Julia, I think the preliminary view of the expert is sometimes a well-meaning kiss of death, because most experts, or many experts in my experience over the years, think they have a ready answer to the problem, and it is in their nature as technically minded people and well-meaning people, almost invariably, to want to give an answer very quickly. And one of the worst things that can happen in litigation is to seem to invite an expert to give that the benefit of their initial views by way of some return email before you've even had the chance to shape up the question with them, because very often what comes back is an adverse answer. They don't even know it's adverse. They think they're being helpful, but what they sent back is adverse. And then what you're stuck with is, number one, a potentially discoverable trail. Privilege isn't absolute. It gives way in certain circumstances. So you then have a potentially discoverable trail. The other thing that you have is a construct in the mind of an expert, sometimes a construct that's mentally as large for them as, the Berlin Wall used to be, or the Great Wall of China. They've created the structure in their mind where they've got an answer, and then you have to spend the next month or two collegiately demolishing it by showing them, for example, that their assumptions are wrong, or that they've misunderstood their instructions, or that they've expressed an opinion without visiting the site, or something like that. So I find it's never a good idea, except in extremely limited circumstances, which are almost always dangerous, to invite one's expert to express any view before you've had the first or second collegiate debate with them about the matter.
Well, then what do you suggest, Sydney? How should the experts be briefed?
Well, as a general proposition, Julia, what I generally recommend to my solicitors is that there's obviously the first initial phone call to work out if, the general areas within their expertise, and assume that's established. How should they be briefed? With the most minimal initial letter, assuring them that their fees are secured, letting them know a little bit about the matter. I know there's a practice out there where many solicitors believe they need to give everything to the expert because it exists in the solicitor's file. I'm not a great fan of that, because it doesn't assist the expert to give them, generally speaking, the pleadings, because you're not asking them to give you an advice on your pleading, nor are you asking them to give you an advice on your affidavits. So I am not a fan at all of attaching the file and conveying it to the expert. I think some very, very, very brief question, maybe something like this: Dear X, this firm is retained in a matter where we seek a statutory easement for stormwater over the land of Mrs. Q. Our client is Mr. X. One of the questions involved will be whether a pipe can be put over the land of Mrs. Q to drain the stormwater, and if so, what would the best place be for that pipe to go? Would you be willing to take this retainer, and if so, when would be a good time for us to meet in person? So that's what I think the initial briefing letter should be. And then the last thing that I think one needs to do in a case like that is give the expert the summons, your initial affidavit setting out the righteousness of your cause and how completely unreasonable and obdurate the defendant is. Because the more you argue your case to your expert, the more you might subconsciously create a bias in them about the matter. And one of the greatest things you can do to enhance your prospects of success is to present in court with an expert who is patently neutral and objective, and who isn't there, who isn't sucked into becoming an advocate in your cause, because the moment the court gets a whiff that your expert is descending into advocacy, that of course dents their credibility. So one has to be very careful about the things that one says to one's expert. So one should shy away from arguing your case to them when briefing them.
Well, what are the benefits of conferring in person, especially on site with your expert then? Could you give us an example from one of your cases?
Absolutely, happy to. There are numerous benefits in conferring in person with an expert. And I think one is to first understand, work out what is it that my role is as a lawyer in this case. Is it just to get some pieces of parchment from someone to convey to the court file, get it duly sealed and say, I've complied with directions. I've complied with directions, and therefore this is off my desk. I think that many people regrettably see the whole process as procedural and being focused on paper, which is there's a set of directions, programming orders are made to serve expert evidence. So you write a letter off and you think you've complied with the order when you get something back and give it to the other side. But very often you've never met your expert. You can't gauge what their body language is like. You don't know how they'll react to difficult questions. Therefore, you haven't performed your very, very first role as a solicitor or a barrister with a duty to your client, which is to work out, will this expert be a good expert in your case for these facts? If you haven't worked that out, then nothing that they say in grandiose language on pieces of parchment is going to help you when the expert gets to either the conclave or to the hot tub. So one of the great advantages of meeting in person is to observe your expert. The second thing that you need to do is to also understand one of the other things that your role is, with the greatest of respect, as either a solicitor or a barrister, which is to build some kind of esprit de corps at some stage slightly larger than 1 minute before you walk into court for opening addresses. How often does one see hassled counsel going grey in the corridors of the court, being flung into an urgent conference with their supposed expert who's flown in a disheveled state from New York, sometimes in one example that I've had actually in their pajamas and a Qantas slippers was presented at court. This actually happened.
Wow.
So, I mean, that was an extreme case, but I mean, very often you see these conferences happening in the corridors of the court. No one has got on the same page with each other. The team isn't singing off the same hymn sheet. Nobody knows each other's personal ways. There's been no opportunity to gel as a team. These things don't happen in the same way that an ant colony operates, where ants can come along and touch each other with some kind of receptors on what I think could be their heads. If ants have heads, I don't know. I'm not an entomologist. But humans do not communicate or work in groups in this fashion. We actually have to talk to each other a little bit beforehand. So I think one of the other great benefits of talking to your witness, other than seeing how they will react in the witness box or in the hot tub or in the conclave, is forming some kind of esprit de corps. So that's another great benefit of working with the expert. A third benefit, and one of the massive benefits of meeting your expert on site, is that the expert, for example, in an easement case, do quite a number of them, so the expert can say in their report, I have conducted a site view. You asked me, can I give you an example from one of my matters? Well, I'll be very happy to give you an example from one of my matters. And the matter of Turvey and Crotty, from memory 2018 or 19 in the New South Wales Supreme Court, was an easement matter. And my client's case in its essence was that she had a right-of-way over a private subdivisional road that ran from sea level up the escarpment through the wonderful and verdant Curramore estate near Kiama. So she said her case was that she had this right-of-way, and her case was that one of her neighbors had erected gates over the right-of-way, preventing my client from getting access to her property, and therefore my client wasn't able to sell her property at an auction because the auction had to be called off. And so that's sort of like a feel of what the case was all about. One of the points raised by the defendant was that even assuming that there was this right-of-way, and even assuming the gates had prevented this particular right-of-way being used, there nevertheless was some other road that could be well seen on some official-looking map, because there was a map that potentially might have been gazetted, or maybe it wasn't gazetted. I can't quite recall the detail, but nevertheless, there was a map, and it showed a road over some other location to my client's property. And so one of the points made for the defendant was that, well, there was this other road. So where was the nuisance constituted by the gates? I think, speaking from memory, that's what the point was about. So this was a perfect example as to why one should meet one's expert on site, because we met on site and we took the map where it was said this other road came from and went to. And when we stood at the point on the land, the map said the road was, and one looked at where the road should have been, what one saw was this intimidating gate topped with electrified wire, secured by a number of padlocks, each of which looked like it came out of some middle-age castle, protecting the front door from like roving hordes. As if that wasn't enough, there was a cattle grid stopping people even approaching the electrified gate. And if that further weren't enough, there was some massive pole upon which sat a menacing CCTV camera aimed down at those who would dare to walk over the cattle grid. So, and then when one stood there and held the map and looked where on the land this road should be, one saw that there perhaps were vestiges of what might have been a track some very, very long time ago. So our expert was able to say, I've looked at this point made by the defendant. I've stood on the site where they say that there's a road, and I can say, having been there myself, that you can't physically get there unless you want to jump over some electrified wire under the CCTV camera onto apparently private land. And I can say further that even if you can do that, you won't actually find any marked out road. There's just some tracks going through some forested hill. So our expert being able to say that, and when it came to the conclave, and the defendant's expert putting in their report that they hadn't been to site and couldn't add anything on this point, it's pretty clear in whose favor the court found on that particular point. So that's an example.
Wow, very interesting. Then what do you suggest as the best way to go about taking the expert's statement? Do you leave the expert to do it on their own in their office and wait for the first drafts and then mark it up and send it back to them? And is that the way you go about it, or do you actually do this together?
Well, I think that's a great question. And I think there are two syndromes involved in the way many people go about doing the reports. The first syndrome is called man in shed, and the other syndrome that I wish to speak about is the ping pong syndrome, because they are allied. I think the best way to go about doing a report after you've met with your expert on site and you've had a collegiate debate in person, like in the old-fashioned way where people used to meet, When societies form, people would get together in person and they would talk. So once you've shaped up the question in person, you then make an appointment either that day or another day to get together to draft the report. I think one of the absolutely worst things that can ever happen in this realm is for the expert to have a stab at writing their own report. Many experts, in fact, most experts, are terribly knowledgeable about their particular fields. Surveyors know how to use the latest theodolites certified by Russian cosmonauts to shine lights onto things to measure angles, but that doesn't mean that they studied English literature and are any good at writing reports. The same thing can be said for engineers who know about all the calculations as to the rate at which water can collect on a roof of a certain area and flow down a pipe of a certain diameter installed at a particular gradient. They're really, really, really good at those types of calculations, and they're assisted by software. But many of those people didn't attend any courses on how to write reports. And they're not necessarily experts in writing reports. Very often, the people who've done these calculations for different projects have never written a report in their entire life. They're just the engineer who's done calculations on another 100 sites, and they've been appointed the engineer for this site, or they've been appointed the surveyor for this site. And if you give them the expert witness code of conduct and say to them, that's good guidance, how to write a report, and you should also read the main case Makita and Sproul's and Court of Appeal judgment in New South Wales to give you some guidance as to how you write reports, they'll go home, their eyes will glaze over and they'll fall into a coma, into their pasta. And what you'll get back is just like a jumble of words that you're going to have to demolish and undo before you start again. So what that means is that the whole team develops asthma. Your expert gets their backup because they feel that you're attacking them. They don't know what they're doing. You feel this is terribly arid and unbelievably boring. So it's a very unpleasant way to earn a living, although it's lucrative, but it's not all about money. So it's very boring for the lawyer. It's terribly confronting for the expert, and the product is terrible if you allow the expert to do a draft. Very often it's terrible. They muddle up their instructions. They muddle up their assumptions. Their assumptions and instructions are spread through the report like stars sprinkled from the hand of some cosmically distracted god. And the things that they've observed on site are also sprinkled. I've never yet met an expert who, unassisted, is able to say in one place the things that they've observed. Like, I attended site, my site inspection began at 9 a.m., and these are the 5 important things I observed that are relevant to this case. Rare indeed. An endangered species like some Patagonian flower found under a glacier. Rare indeed is the expert who can, by him or herself, put all of their instructions, all of their assumptions, and all of their observations in one place. So what is my way? I like to get together in a room with my expert in the old-fashioned way of people talking face-to-face and assist the expert with matters of form. For example, introduce themselves, introduce their speciality, and just to take an example, many experts seek to prove their speciality by taking their curriculum vitae, drafted for some finance application 5 years ago, as if that proves that they can give evidence about this particular case. Most experts can't work out that you actually got to say how your curriculum vitae and what on your curriculum vitae is actually relevant to this particular case. So you just help them with setting out how the expertise is relevant to this case, what the instruction is, what the difference is between an instruction and an assumption. how it is to set out the things that they've observed on site that they consider relevant, then how it is to set out the things that they've been briefed with, like what pieces of paper, for example, development application, or an opposing engineer's calculation, what very limited pieces of paper they've been given are relevant and that they propose to refer to. Perhaps in that category you can put literature that they've got from a textbook that's relevant to this case. For example, Bureau of Meteorology records of 1 in 25-year rainfall events, or 1 in 50-year rainfall events, or something like that. So you help them set that out. And so that's the way I prefer to go about doing reports with an expert. But that's just a personal preference, because I'm not saying that's the only way. I'm just saying that's what I think is a better way.
I see. Also, you just mentioned that experts should be neutral and objective, and also it's the duty of the experts to assist the court impartially under the UCPR, and also the duty overrides the witness's obligations to their own client, and the expert is not an advocate for a party. How is that achieved with the approach you suggest?
Good question. And I can see why you would ask that, because there's always a feeling, I think, amongst certain experts that if you call them into a conference, they are a bit concerned that they will have their will overborne by the lawyers.
That's right. They might be affected or influenced. I'm not sure. Yeah, they might be thinking that. So how would that work?
So I think good question. I think one of the ways to cater for that, and that's a real concern, is in the initial broad brush letter that is sent to the expert, or one attaches the expert witness code of conduct, or at least a link. If you know this expert has done other expert reports before, you can just say, I'll take the opportunity to remind you of the code, and here's a hyperlink to it, and they'll probably have it printed out anyway. If it's an expert who's never been an expert in court before, print it out and send it to them. So you emphasize from the beginning that what you want is for them to be objective and to discharge their duties as an officer of the court. I think it never hurts at the first inspection on site to tell your expert that one of the things you want them to be is completely objective, even if it's contrary to interest, because it's much better to hear from them at an early stage if they have an adverse view, rather than hearing it from the other side's expert in a conclave, and then finally in a judgment of the trial judge, and finally in a judgment of the Court of Appeal hundreds of thousands of dollars later. So I think it's a really good idea to tell your expert you just want to hear from them the way it is. And if you tell them that straight, everyone will respect that, and they will feel more open to telling you what they really think about the case. Just say to them, tell me straight. Do we have a point here or don't we? I'd rather hear it from you now at an early stage than, particularly if you have any caveats or reservations about what you have to say. Another way of emphasizing that to your expert on an emotional or psychological level is to say to them is that we're now going to play a little game, which is they are to pretend they're the expert for the other side and say, okay, well, you've now got the brief for the other side. What are you going to say? How are you going to argue the case for the other side? I really want you to step through that process to tell me what the weaknesses are in the arguments you've given for us. And then when you show them that what you want from them is the unvarnished reality, that then will prepare them and make them slightly more at ease, or much more at ease, depending on whether they've worked with you before or not, about actually coming to a conference with you and writing up their report in conference. So you actually show them in reality that that's the professional relationship that you want.
I see. Great.
Yeah.
Great point. So could you summarize a couple of tips that we've discussed today for the audience?
Absolutely. So here are my tips, colleagues, and I hope they prove to be some use to you in practice. So number one is, when the time comes to retain an expert, have only the briefest of description about the case to the expert. And of course, let your expert feel comfortable about their fees, even if there's sort of limits placed on that. So that's number one. Broad brush letter. Number two, meet your expert in person as soon as you can, so you can perform your professional obligation to your client to gauge whether this expert is a good fit and form your own assessment as to how they will conduct themselves in a conclave, i.e. will they be able to stand up to the pressure of a senior colleague briefed or retained for the opponent, because the way these conclaves often run with technically minded people is that there's a pecking order in town, and the junior engineer will generally defer to the senior engineer, because that's just the way things work by and large. So ask yourself, how senior is the person that you are retaining? How will they react in a conclave? How will they answer questions from the court? Are they direct in their answer, or are they diffuse in their answer? So form your opinion of them. Then when the time comes to actually take the report, if you decide to before you go any further with them, ask them when you meet them in person, say to them, if you were to give a report on this matter, are you able to give me any tentative indication of what you are likely to say in the report? And just tell me the unvarnished truth as to what you really think. Then get their tentative views, because that will guide and inform whether it is appropriate to then allocate further budget for the matter to get them to write the report. No point getting a $20,000 report that is in the realm of removing an ant from your foot with a 12-gauge shotgun, because it might cure the itch, but it might cause another particular problem. So get their tentative view. Then when the time comes, at all stages that you talk to your expert, reassure them that what you want from them is the unvarnished reality, because that is the best thing for everyone involved, primarily for the client, secondarily for their reputation, and thirdly for your reputation. Those three things align like an old-fashioned viewfinder in a Nikon camera. If anyone remembers those days where you had to focus on objects, all of the things align, everyone's interests align if they tell the unvarnished truth. Then when the time comes to take the actual report, get the expert in a room together with someone who's done any number of reports. I think one of the greatest mistakes made that I see out there in the profession is where a very junior solicitor in a firm hierarchy is allocated to take the first report, the first draft of the report. And sometimes this leads, more than sometimes, this leads to a situation where there is insufficient separation of instructions, assumptions, observations, relevant documents, and application of expertise to a conclusion. It might be fantastic training for the solicitor to go through all of this. That might be something useful for them to progress in their career, but that's not the way I am suggesting reports be taken. The person who needs to be in the room with the expert is someone who can help them understand all of the workings out of the expert witness code of conduct and cases like Makita and Sprouse and colleagues That's how I suggest one goes about doing reports in terms of practical reality.
Wonderful. Thank you very much for your great tips, Sydney. That was a wonderful and very informative session. Thank you.
Thank you too.
And everyone, please go check out Practical Guidance Dispute Resolution.